Good morning, everyone. Welcome to this webinar on environmental outcomes reports. I preface it by saying that by coincidence, today is the government's Energy Security Day, and my colleague Megan has already posted a link in the chat to a written statement from the Secretary of State setting out all the things being announced today. But don't look at that until I've finished my presentation. But the main document being published seems to be called Powering Up Britain, or perhaps PUB for short. This is actually the court-mandated revised net zero strategy, which was declared unlawful late last year, and the government were obliged to publish a new one by the end of March. So they just made it by one day. So, but anyway, on to this webinar, which is about environmental outcomes reports. I will just start sharing my slides. There we are. So I've declared it bringing clarity to complexity. So am I talking about the environmental outcomes reports or me bringing clarity to this subject? We'll see. So for the next hour, I will go through what we know about how this is all going to work. There will be an opportunity to ask questions, and I will attempt to answer them after I've finished going through all my slides until we get to 10 o'clock, which time I will stop. There will be a follow-up. I'll go through all the questions that anyone asked and write answers in writing, and they will be sent to you along with a copy of the slides and a recording of the webinar, hopefully by tomorrow, maybe Monday. And feel free to share everything. This recording will also be on our YouTube channel. If you're having any technical difficulties that aren't at your end, then do post a message in the chat. My colleague Megan will have a look at those, and if she can do anything, she will. I'm not going to look at the chat though. If you have questions about the webinar, the content of the webinar, please post them using the Q&A button, and I will go through them at the end in the order they were received. So what's this all about? I'm going to cover what environmental outcomes reports are. On the 17th of March, the government published a consultation on them. So we now know a bit more than we did a few months ago. I'll go through how the new process to replace environmental impact assessment is appearing that it's going to work, make a few comments about it, say what I can about the timing, and what's going to happen next that we know. So I should preface this, and I do preface this with a health warning, that the proposals are still at an early stage. They're not even enacted by Parliament yet, although since I last did a webinar on this in, I think it was September, they've got a bit further. They are at committee stage in the House of Lords at the moment. The next sitting dealing with it is the 18th of April. The particular part of the bill that contains all these new proposals haven't been reached yet, and there are in fact one or two amendments to those clauses from the government. I'll mention those a bit later. So they're likely to change, they will change further. The consultation has only just been issued 13 days ago on a Friday. And it is fairly high level, and the real meat of what's being proposed will be in some regulations which I would predict are not going to be available for at least another year. However, you do need to plan ahead for these things. Large projects, which is exactly what these will apply to, take a long time to develop, and so you may, even if you're thinking about the early stages of a project, may have to follow this new process by the time you make your application. Listen to me, yeah, I'm clicking, but nothing's happening. Here we are. So the consultation was published on the 17th of March, and it will close on the 9th of June. So that's a good 12-week proper consultation period. Quite a lot of questions, 26 questions. They are sprinkled through the document, and they are also all collected together at the end. The materials surrounding the consultation, it's really only the main consultation document. There's a very brief cover page, and there are brief reports. Apparently they have to report every 5 years on performance of the Town and Country Planning EIA regulations and the Infrastructure Planning EIA regulations. So they've done that, but that's very brief and says, oh, it's all far too getting out of hand. All these things are far too big and cost a lot of money. It says phase 1 of a railway advertised for an environmental statement at a value of £1 million is their example. I presume that's HS2, although it doesn't say what it is. The links here on this slide, you will be able to click through when you get copies of the slides. But the main consultation document is the one. So what is this new concept? So it is going to replace environmental statements for the environmental impact assessment of projects and environmental reports for the strategic environmental assessment of plans and programs. I'm predicting by 2025, even that's looking a bit optimistic by now. They are in that bill, the Levelling Up and Regeneration Bill, and they're in part 6 of the bill. It used to be part 5, now it's part 6. If you click on that link, you'll get the latest version of the bill, although it will change further and that link will become out of date. So the idea is going to comprehensively replace environmental impact assessment and strategic environmental assessment. So this is a big change. Those regime, well, the EIA has been in force since about 1990, and SEA for slightly less time, since about 2000, I think, or 2005 or something like that. And it applies to all the big developments. And it's not just a town and country planning. If you look at what's currently clause 152 of the bill, it lists 18 consent regimes that are going to change. Although the consultation document says it is based, the document itself is based on the town and country planning and infrastructure planning mainly. So all these sort of less common ones like pipelines and oil facilities have their own, and highways have their own separate EIA provisions, will be also have them replaced. There are new concepts to learn and new names for old concepts. Case law, I think, will largely have to start again because it is all the thresholds and different aspects of the regime are changing. So, environmental outcomes, plural, reports. Don't call them environmental outcome reports. They are going to be the replacement for environmental statements. And indeed, although I'm really focusing on them, but they will also replace the strategic environmental assessment version, which are called environmental reports. The idea is, instead of simply, not really simply, but instead of just reporting on the effects of your project on the environment and how negative impacts will be mitigated, as environmental statements currently do, environmental outcomes reports will be more dynamic. So instead of on the static or the current baseline of the environment, they will be reporting their effects on efforts to improve the environment. So these are what the outcomes are. So these are government set outcomes. They're not outcomes that you on your project are trying to achieve. They are what the government is trying to achieve nationally. And you have to report your effect on them. So over time, these outcomes will change. They'll probably be tightened and broadened, reflect changing priorities. Air quality, we're focusing on particulates a lot these days when we didn't used to be, that sort of thing. So it's a more dynamic background against which projects will be measured. The consultation document In my previous, by the way, in my previous presentation, I gave an example of air quality, but the consultation document gives an example, an appendix of biodiversity. And they say, here's an example outcome, an increase in the abundance of protected species and supporting habitat. That seems a bit vague to me. It doesn't give a time scale or a level of increase or anything. However, at the end of January, the government published its second 5-year plan for improving the environment. The one in 2018 was called the 25-year Environment Plan. The new one is called the Environmental Improvement Plan. And it has some targets in it. And the one that corresponds to that example is halt the decline in species abundance by 2030 and then increase abundance by at least 10% to exceed 2022 levels by 2042. I don't actually quite understand that. Increase abundance by 10% to exceed 20, what does that mean? So does that mean it's currently going down, as long as it stops going down by 2030 and increases from the 2030 level by at least 10%, which is then greater than the 2022 level by 2042. What a strange outcome. But anyway, even that isn't massively specific because it doesn't say what species we're talking about or supporting habitat, but it is presumably species protected by law, such as bats, badgers, and rarer ones. So the idea is your project, if a bit like air quality, where you can't slow down achievement of the air quality thresholds or make tip over the thresholds if we're under the threshold already, your project will not be able to halt the decline of a species or the subsequent increase in abundance for any given protected species. So if your project is near the habitat of one of these species, then you will have to provide mitigation, if you can, to limit your impact, or compensation to provide an alternative increase if you can't stop your own local decrease, according to the so-called mitigation hierarchy. So this abundance target, it only goes up to 2042, so presumably that will be extended eventually and probably tightened, and maybe the number of species will be broadened, or if abundance is achieved, maybe some species will be dropped because they're sufficiently abundant. So it's much more dynamic. These outcomes, that was one example, and they're not set out anywhere yet, but they do seem to resemble the targets listed in that environmental improvement plan I just mentioned. The committee stage in the Commons, the minister said the outcomes would be fairly high level and user friendly, simply setting out environmental priorities. But actually, I think that sounds vaguer than they really will be. And the targets in the environmental improvement plan do not appear to be wholly suitable for measuring projects against. For example, one is, again on species abundance, is restore or create more than 500 hectares of wildlife-rich habitat by 2042. So if you're building something somewhere, you can say, well, I'm not really stopping anyone restoring or creating that number of hectares somewhere else. So I'm not sure how ones like that will be translated into more project-specific ones. But presumably if your project does restore or create some wildlife-rich habitat, that would be a good thing, and you can point to the outcome if there is one like that. Say, look, we're helping it. What I wasn't expecting is the outcomes are going to be enshrined as statutory instruments. So they're going to be law rather than just a published document with some numbers in it. Not clear if it's all going to be one statutory instrument that's got them all in, or they'll all be separate ones. We'll wait and see. They will all be subject, a bit like national policy statements, they will be subject to public consultation and parliamentary scrutiny before being set, although they're actually going to be more entrenched than national policy statements because they will be statutory instruments. Each outcome is to have a responsible owner who is going to monitor its progress. I'm looking at you here, Natural England. I can imagine you will have a lot of them, but not all of them. The outcomes, it's going to be interesting how they are going to define some of these. I mean, we're used in environmental statements to having things like visual impact. How are they going to turn that into an outcome? We're going to make the country 15% more beautiful by 2035, and then you're going to have some sort of aesthetic measure. So some of these are a bit more difficult to capture, I think. So that's going to be interesting. And that probably wouldn't be Natural England that would look after that, it would be somebody else. So let's go through the traditional environmental impact assessment process and see what's going to change. So the news, if you're not familiar with screening, screening is deciding whether currently you do need environmental impact assessment or not. So it's a binary decision, yes or no. So there is going to be screening under the new regime. However, the thresholds are going to be more objective, is the idea, and hard edge. So it's going to be much clearer, because the government's analysis is that screening is the source of a lot of litigation. Normally developers wanting to avoid environmental impact assessment because it costs a lot of extra money. And then somebody affected by the project then takes them to court and says you should have done EIA, and that's taking up a lot of time. And that is probably because it's quite subjective at the moment, what requires EIA and what doesn't. At the moment, there's in all the different EIA regulations, a Schedule 1 list of mandatory projects and a Schedule 2 list of projects that require EIA if they meet thresholds, and the thresholds are generally just if they're likely to have significant effects on the environment. So you can see there's a lot of scope for argument there. But I think the intention of the new regime is again going to have, they're going to be called Category 1 projects and Category 2 projects rather than Schedule 1 and Schedule 2, but pretty much the same. But the Category 2 ones will have much harder subjective thresholds, like this is not in the consultation document, this is my invention, but say it's going to be, are you within 2 kilometers of a special protection area or not? So you simply get your ruler out and then you'll know if you're in or out, and nobody will be able to disagree with you if you've done it correctly. So the idea here is to reduce litigation on this binary decision of screening. The next big topic that currently happens is scoping. This is asking the decision maker that you're going to make your application to what your environmental statement should contain. It is optional, but it's always a good idea because you will know what the decision maker is thinking in advance rather than be surprised later. The government's analysis here, rather than litigation, it involves a huge amount of work with scoping, and we're not even getting to the application and the environmental statement yet. It's a pre-stage that is an industry in itself. So they're saying there are thousands of pages of documents that we think are unnecessary. So big news on scoping is the government's pretty much proposing to scrap scoping altogether by saying every project scopes every outcome in. So there you go. Although there's a slight wrinkle to that, it says, unless an outcome is obviously unaffected, then you don't need to assess your project against it. And the example it gives, if you're doing an underwater project, then you won't need to assess the air quality outcomes. So there are not very many projects are carried out underwater, so I can't see this going to happen very often. And even underwater projects might have emissions that reach the surface and do have an impact on air quality, but so even that one looks a bit dodgy to me. So scoping is out, there's the big news. And everything is scoped in. So the next one is you make your application with an environmental outcomes report, an EOR, instead of an environmental statement. Consultation says that an EOR will look like this. A short introduction. The word short appears quite a lot in their description. A short, high-level summary of how alternatives and the mitigation hierarchy has been considered. And there's quite a lot of emphasis on considering alternatives and the mitigation hierarchy earlier in your project development than currently, so that it's sort of woven in all the way through the process. And another point to note here is this is where the government is changing the bill. It had 5 stages in the mitigation hierarchy listed in one of the clauses, which was improvement. How are you going to improve the outcomes? Then if you're not going to improve them, how are you going to avoid them? Then if you're not going to avoid them, how are you going to mitigate them? Then if you're not going to mitigate them, how are you going to remedy them? And I didn't really know what remedy meant. And finally, if you're not going to remedy them, how you're going to compensate for them, for damaging them or slowing them down or something. So the good news is the government are removing the word remedying from the bill. I think I wasn't the only one who said, what are you talking about? And they've realized that that was just a new invention that didn't actually exist. And they're also moving improvement. It's still there, but it's not in the mitigation hierarchy. It's elsewhere in what is required for an EOR. So the hierarchy only has 3 levels instead of 5 now, or will do once the amendments to the bill happen next month. So that's what you've got to do right up front in your EOR. This is before we get to the individual outcomes. Then for each outcome, so this is a bit like your traditional topic chapters, it says you set out 5 things. The residual effects of your project on the environment, relating to this outcome presumably, what the current baseline and the relevant trend data, i.e. which direction things appear to be going from the current baseline. So those are quite traditional, like an environmental statement. And also they want a commentary on the levels of uncertainty in the figures you provided. Then it says, then you set out your proposed mitigation. Although it just uses the word mitigation at this point in the document, it's probably meaning the 3 stages in the mitigation hierarchy that are listed above. And then you're going to set out the monitoring proposals to show what actually happens when you start to implement your project and the effectiveness of the mitigation, compensation, etc. you are proposing. So then after all the the outcome chapters, a summary of the contribution of cumulative effects on outcomes as a whole and the relationship with plan level assessments. So this is another quite big feature of the consultation document, that the idea is there'll be the equivalent of strategic environmental assessment of plans. So there'll be an environmental outcomes report for local authority plan, national policy statement, those sort of high-level documents. And then the idea is, how realistic this is, we'll see, that the individual projects can look back at that plan and say, oh, all those things have already been assessed, so I don't need to put it in my own EOR. And there'll be hopefully more of a correspondence between the plan level EOR and the project level EOR. So that's where that ties in at the end of your EOR. So there's an EOR. Hopefully your EOR is fantastic and the consenting body gives you consent for your project. It's worth noting that as currently, saying something in an environmental statement does not necessarily commit you to doing it unless the consent you are given actually spells out that you have to do it. So in your conditions of your planning consent or your requirements attached to your, or even articles attached to your development consent order under the Planning Act, it's only if they require mitigation or compensation to be provided, do you actually need to provide it? And that's still going to be the case. The concept of adaptive mitigation is encouraged. So that's where the mitigation varies according to what the effects actually are. And that's quite likely to be that you propose wider mitigation, but in fact you only need to implement less when you actually come to measure it and find out that on the ground it's not as serious as you had assessed as a sort of worst case situation. So the mitigation can adjust as the effects occur. I think you'll still need to show that you have available the maximum mitigation that you might need to provide. But that's this fairly new concept of adaptive mitigation is being encouraged. The consultation doesn't say much about compensation, so that's where you're accepting that you're going to it's going to harm the achievement of an outcome in this case, but you're going to do something somewhere else that will improve the achievement of the outcome to offset your harm. It's a bit like biodiversity net gain in a way, offsite BNG. But that isn't mentioned that much in the consultation, but presumably it will be similar to how it works currently. It does talk about remedial actions if your mitigation doesn't work or the effects are worse than you predicted. And it's not clear if those need to be suggested even before you get your consent in your environmental outcomes report or not, or it's just something for the local authority and it's monitoring after the project has been consented to force upon you if things aren't working out as you said they would. So we'll have to wait for the consultation response and the regulations to see about remedial actions. So that takes us on to finding out whether the project is the environmental environmental mitigation compensation you have proposed is working through monitoring, and it says monitoring will be mainstreamed. I don't like this tendency to turn nouns into verbs, but there we go. I can't resist it. There's a section on mainstreaming monitoring. It says, according to their analysis, mitigation that is proposed in an environmental statement are often not being implemented. Tut tut. But it actually puts this more at the door of local planning authorities than developers. That it says LPAs are too busy, under-resourced to carry out proper monitoring of whether developers are doing what they said they would do and whether the environmental impacts are what was predicted. So I would have thought that it ought to be developers monitor their projects and provide the monitoring data to the LPA, who can then check them and perhaps do a sample of its own monitoring just to make sure that the developer is reporting it correctly, rather than putting the whole burden on them. But that's what's currently seems to be the case. Interesting, it says that waste and minerals and offshore wind monitoring is done well, as examples. So well done, county councils, you're doing good monitoring. What I think is rather a good development is that reporting the effectiveness of mitigation will be available generally, so that future projects can know whether mitigation works, what mitigation works and what doesn't, and then can do the mitigation that works rather than the mitigation that doesn't in the future. I think that's rather a good idea, and I hope that will be obviously published somewhere that you can look up rather than having to scrabble around under each project and see what the monitoring reports say. There will be an enforcement regime specifically for EORs. It looks quite like the traditional enforcement regime for breaches of planning consent, but it is specific for EORs. So there's a bit more muscle behind this than currently. Then finally, there's this concept of reporting rather than monitoring. Reporting is not project specific, it's about the achievement of outcomes in a local authority area overall, rather than relating to any particular plan or project. And that has a clause in the bill as well. So next steps. Consultation, as I mentioned earlier, ends on the 9th of June. Consultation response will be published in due course, noting that for biodiversity net gain, the consultation ended in March 2022 and the response was published in March 2023, or possibly February. So it's pretty much a year before you get a consultation response. Regulations will be published subsequent to that. We don't know how long until the regime comes into force after the regulations are published. And in fact, that's one of the questions in the consultation. Should it be 6 months later, a year later, or 2 years later? So it'll probably be one of those. I can see developers all saying 2 years and everyone else saying 6 months. So it'll probably be a year. Then there'll be the overall EOR regulations, and also, as I said, the outcomes are going to be statutory instruments themselves. So they will probably be separate to the overall regulations. They may even be separate from each other, or they may be one big statutory instrument. And I hope that a lot of guidance will be prepared to accompany this new regime. Otherwise, there will be a lot of uncertainty, which will put off developers from making applications. So that's guidance not just from the government, but probably from statutory bodies and trade bodies and all sorts. Everyone's got to join, got to cooperate on this and provide guidance on what developers need to do, and local authorities for their plan level EORs. So here's my commentary. Some comments. So I think it is a good idea to reset the regime of environmental assessment, because it's definitely got out of hand. If you look at the size of environmental statements, a good example is in my area of Planning Act in nationally significant infrastructure projects. The size of the environmental statement for the Hinkley Point C nuclear power station, and then 10 years later for the Sizewell C nuclear power station, I mean, it is much, much bigger. It's the same developer doing almost the same project in a different place. As an example of how it's got out of hand, and it's an industry in itself. Not that that's necessarily a bad thing, but the very size of these documents mean they're very difficult for particularly the general public to understand. So resetting is a good idea. As I mentioned, there's 18 different statutory regimes that have their own EIA regulations, and it says while this consultation is based on Town and Country Planning Act 1990 and the Planning Act 2008, there will be a tailored approach for different regimes. Each regime will develop a tailored approach. So I'm not quite sure how that's going to work. A regime isn't a thing that can develop something. And that runs counter to the concept of consistency across the regime, so that it's easier to understand. If you know one regime, then you can understand another one. So we'll see what happens there. These outcomes are going to be obviously the key to this whole regime. I think the government do have a challenge to make sure they're not so vague that every project gets consented, because it will have a tiny impact on a national outcome, or so precise that no project will get consented, because they will always harm a very precise outcome. It's got to be somewhere in the middle, so that EORs are as effective and rather possibly a little bit tighter, but certainly not looser than current environmental statements. And indeed, there is a non-regression clause in the bill that says it will provide no less environmental protection than the current regime. So that's the key. I can't see a way to set these outcomes in some areas, but they'll obviously have a go, and we'll see what happens. This earlier consideration of alternatives in the mitigation hierarchy is stressed throughout the document. How realistic is that really? Projects do not, in fact, have a perfect linear progress from, oh, let's do something and see what needs to be done, and see what the plan says, and do something that fulfills the plan, and then gradually develop it to making an application. They don't work like that. They say, I've got some money, some land. If I'm a private developer, I want to make some money on this land. Here's my project. Oh, let's see what the alternatives could have been to that project. It's usually not done in the most perfect logical order. So we'll see how realistic that is. As I mentioned earlier, these remedial measures, if your effects are worse or your mitigation doesn't work, it's not clear if you need to say what you're going to do in your environmental outcomes report, or that's for something to be sorted out later. We'll see. But a good thing in the consultation about this effectiveness of mitigation being available for others to see for future projects, I think is a great benefit. And I hope it's harnessed perhaps in some sort of national repository, rather than each project's monitoring under some local authority website or several websites. So I hope that one is made clear for everyone to see. Okay, here's a very quick comparison to summarize the new process. Screening is going to become less fuzzy, is the idea. Scoping is almost being abolished altogether. Significant effects. So the effect is whether you're going to impede government declared outcomes rather than what your impact on the current baseline or predicted baseline at the time of your implementing your project is going to be. Residual impacts, the way the bill is couched is that there shouldn't be any impacts on achieving these outcomes. You shouldn't get consent if you're going to hamper achieving the outcomes. I'm not sure how realistic that is, considering that under the current regime, most projects do have some negative impacts on the environment, but they are weighed in the balance with the benefits, and given consent of the benefits outweigh the impacts. So we'll see what happens with those. Monitoring, there is a lot more emphasis on ensuring that that happens, and so it's got an enforcement regime. So there's a lot more focus on that, and we'll see if that really works. And then finally, there's these remedial measures that are mentioned. Whether they're set out in the application or afterwards remains to be seen. There's something for everyone. I know a lot of different people from different disciplines are signed up to attend this webinar. Thank you very much for attending. So developers obviously have to plan early, because if you are going to make your application by sometime in 2025, you might be caught by this new regime, and get good advice, particularly from lawyers, who are the ones who seem to be on top of this regime in particular. Third parties, those affected by projects, hopefully it'll be an improvement that these will be simpler documents. EORs will be simpler than 1,000 pages of environmental statement. But currently environmental statements, they're fairly clear once you wade through all the methodology and baseline and get to the end of the chapter where it says what the residual impacts will be. It talks about impacts on receptors. It remains to be seen whether that's still how things are going to be expressed or not. So they may be a little more vague in terms of working out what the impact on you is. If it's talking about species abundance, impact on species abundance, what does that mean if you live at 20 Church Lane? What's the impact on you? We shall see. Statutory bodies, they have a lot of standing advice and guidance, which they'll need to rewrite. And obviously they are involved in the authorization process under all these different regimes. So their role will change and have to apply to these outcomes instead of environmental statements. Environmental consultants obviously have the biggest change to their role. Basically a complete overhaul of what they have to provide. So they certainly are going to have a new job in a couple of years' time. Solicitors often advise on compliance with the law for major applications, and that advice will have to change. And barristers, as I mentioned, case law on screening and scoping in particular is going to be, the slate is going to be wiped clean, basically. But no doubt there will be challenges, despite the government's best efforts to avoid them. So there'll be a whole new set of case law. So that's good news and bad news there. Right, how are we doing for time? Okay, I have 16 minutes to answer your questions. I've got 21 already. But please keep them coming. If I don't, I'll stop at 10 o'clock and answer any that I haven't answered by 10 o'clock in writing and provide those answers. So, and I haven't got no notice of these questions. So, and also, obviously, I do not have perfect knowledge of this regime, even what is available on it, and much of it is not yet known. So, with that further health warning, let's dive in. How will proposed changes affect devolved administrations, e.g. Scotland? As far as I'm aware, this is only going to apply to England, this change in regime. So Scotland, Wales and Northern Ireland will continue to have environmental statements unless they change their own regimes to match. But I will double check that after the webinar is finished to see what the extent in the bill of these provisions are, but I'm pretty sure it is England only. Okay, next one. What are the implications for the Planning and Compulsory Purchase Act 2004 and the requirement for SA, which is not mentioned in the consultation? SA, strategic assessment. Well, this is a plan level and a project level replacement, but I'm going to have to look into what is meant, what you mean by what is in the Planning and Compulsory Purchase Act 2004. I'm sorry about that. EORs will surely be known to all as EORs. Any more Winnie the Pooh puns to get us through this consultation? I'll have to think about that. But EOR was a fairly depressive type. I'm more of an optimist, so I'm more of a Tigger, and I hope this new regime is going to work. On biodiversity, it could mean 1, use biodiversity net gain for projects. 2, drive improvement from the supplies and suppliers to ensure low impacts on ecology. Well, of course, yes, we have got biodiversity net gain coming in later this year for projects, and the same land for improving environmental outcomes will almost be able to be used for BNG and improvement of environmental outcomes, although BNG does say at least 10% of the land will have to be just for BNG, so it's not an entire duplication, but it is going to be interesting how these two things interrelate. There seems to be plenty of statements around government policy about enhancing the landscape. Anything, anywhere about how such an outcome might be defined? Well, I think these more aesthetic ones are going to be very difficult to define. The consultation document does not attempt to do that. I think a lot is going to rely on what people say in their response to the consultation. this consultation does appear to be more of a, whereas most consultations like the BNG one is, here is what we are proposing, what do you think? This one is more like, what should we do about this? We've committed to replacing the regime, give us some ideas of how we're going to do it. And the less sort of numerical outcomes for improvement are going to be the most difficult to encapsulate, I think. But I haven't seen anything yet on landscape improvement. Will this apply in Wales? No, I don't think it will, but we'll confirm. Do you think there will be any crossover to the HRA process? Well, the government has committed to changes to the HRA process. Obviously, having left the European Union, we now call Natura 2000 sites something else, more British sounding. And I think there will be a crossover, yes, like that species abundance outcome is quite like not harming the habitat of a protected species. So there will be quite significant crossover, I think. I have another meeting now, but wanted to hear as much as possible for you. Okay, good. Looking forward to the recording and full slides. Those will be provided. Thank you. So far, this appears to have scope to be more onerous and create more scope for challenge than the current regulations. Well, indeed, yes, it has the scope to be more onerous. It also has the scope to be less onerous. Although in a legal way, it's not allowed to be less onerous. But then you're going to be comparing very different things, and it's going to be quite difficult to say definitively whether something is less onerous or not when it's comparing apples and oranges. There will certainly, as with the introduction of any new regime, there will be legal challenges until it settles down. So I think that comes with the territory. In terms of adaptive mitigation, is there any sense of the monitoring period required? Some impact will be medium to long term, so adaptive mitigation options should cover a long period. Is there anything about this in the consultation? I have read the consultation 2 or 3 times. I don't think there is anything about the length of monitoring period. I guess if the outcome is tied to a particular year, then one ought to monitor it until at least that year. But that is just pure speculation. I will confirm in writing whether it says anything more specific about length of mitigation. 2 questions here really, but as is currently the case with screening, if you know your project will breach screening thresholds, can you go straight to drafting an EOR instead of screening? Where is your opportunity for engagement with statutory consultees prior to EOR submission if there is no scoping? Good questions. I'm pretty sure, yes, you will be able to go straight to drafting an EOR instead of screening. Certainly under the Planning Act regime, the alternative to screening is simply announcing that you are going to provide an environmental statement, so that's likely to be similar. And that is also a good question because, of course, scoping is an opportunity for engagement, not just with the decision-making body, but the statutory, particularly DEFRA family, as it's known, of statutory consultees like Natural England Environment Agency, Marine Management Organisation, and so on. So I will double check, but I think you will probably just have to do your own engagement if you want to find out what these bodies' attitude is to what you're proposing. Certainly with the Planning Act 2008 regime, there is compulsory pre-application consultation, and that will remain. So at the moment it requires preliminary environmental information. That is not currently changing. Well, certainly the term is not changing, but what that information is probably will change because it will have to match EORs rather than EIA. So best practice is, of course, engagement with these consultees, and it may need to be done more voluntarily. For NSIPs that rely on, that's nationally significant infrastructure projects that rely on the Secretary of State to be the discharging requirements authority, so that sounds like National Highways ones in particular, will the Secretary of State also be the monitoring authority? Seems a bit rich to pass the burden to LPAs who've been kept out of the process up to that point. Well, that is a good question, because the Secretary of State is pretty efficient in the Department for Transport at discharging requirements, but as far as I'm aware, does not conduct monitoring. So it may well be the local planning authority that can get that burden. One would hope they are appropriately funded to do so. It seems possible, likely, that the regulations implementing these changes will fall into the next Parliament. Is it expected the changes will still take place in the current form in that event, or might they be subject to further change? I did read the debate in the House of Commons committee stage on that part of the bill. There didn't seem to be an objection in principle to from the Labour representative, if there's a change of government, to that part. So it looks as though there won't be a complete reversal. I haven't seen any announcement that it would be scrapped, but inevitably everything changes when there's a change of government. So yeah, there's an extra element of uncertainty. We shall see. I haven't seen any specific announcement that the Labour Party would junk the regime if they got into power. So you may cover this later, but I am interested in transitional arrangements. For example, if we are required to assess cumulative impacts against an LPA, Local Planning Authority level plan, EOR, this will not be in place straight away. Yeah, that's a good point. That of course, if it's switched on for plans at the same time as projects, then projects will have to have EORs before there is one for the plan that they are operating under. It'd be interesting to see if plans come in first, but at the moment there's nothing definitive on that. Do you think it is likely this will have any knock-on effects to the rest of the UK? This is a popular question. Well, it would be frustrating if it's a different regime, a substantially different regime in different parts of the UK. But I'll check what the application is and if any of the other devolved administrations have said anything about this and get back to you in writing. What is the geographical scope? Yeah, same question. Size of reports, whether EIA or just ecology ones, many excessive size with padding by many consultants that is not required to judge project, such as repeating in full the legislation, etc. Oh, what a scurrilous allegation that there is padding in environmental assessment. I don't think it's deliberate padding to generate more work. It is more paranoia that if you don't put everything in there, then you'll be criticised for having an incomplete environmental statement. Because there are challenges on that grounds, and there is a lot of scrutiny during examination of projects. But yes, definitely one of the main objectives of this is to reduce significantly the size of the reports. Has there been any mention of human health and well-being outcomes, which are themselves quite complex and not appropriate to single-use metric target? There is little discussion of the individual outcomes in the consultation. There's one example of species abundance given at the appendix. The environmental improvement plan that was issued at the end of January does have some more on targets, and it may mention human health and well-being. But generally this is focused on impacts on the environment rather than on human beings. We shall see if there are outcomes about human health. Okay, we've got 2 more minutes left. I will answer a couple more. We have a few DCO projects with submission date 2026. Is there anything we should do now to prepare for EOR? Well, I think you ought to instruct this firm on your projects, and then we'll make sure you are well prepared. Well, all I can say subsequent to that is obviously keep an eye on the timing of this regime and the details as they come forward. we will make sure that our clients are kept up to date, and I will hopefully have follow-up webinars as well, as the details, probably the next one might be not until the consultation response to this consultation comes out, or there are any more significant developments in this area. But it's just a case of getting good advice that keeps you up to date in what's happening. Okay, one more question. Will there be a loss of site-specific detail as the targets are of a national scale, so we may lose nuance in the assessment and miss local scope, impacts and effects? Well, indeed, I think this is one of the trickiest areas for this whole new regime, is not to make it a national target that means you can harm something locally and say, well, it's not really affecting the national target because it's such a tiny percentage of the national target. That is going to be the whole essence of this regime, the test of whether this regime works or not. So on that note, I am going to bid you farewell. Thank you very much for listening. I hope that was useful. As I say, you will get slides, recording, answers to questions subsequently, hopefully even as early as tomorrow. But until then, thank you very much for listening, and I'll leave you to get on with your day. Thank you and goodbye for now.